All right, so this video is about the several different cases that deal with the First Amendment. So in class, we remember the 5 things protected by the First Amendment are freedom of speech, freedom of religion, freedom of the press, the right to assemble, and the right to petition the government. So the first case we'll talk about is Schenck versus New York. So in this case, the Attorney General of New York had distributed a bunch of flyers urging people to not sign up for the military draft or to not comply with the draft order, arguing that it violated the 13th Amendment's provision against slavery. So he was charged with something called the Espionage Act, which says that you can't be working against the United States. And essentially here, Schenck said that this law and the application of it here was unconstitutional because it violated his right to share his opinions, essentially to petition the government. The Supreme Court disagreed, saying that the government is able to regulate and ban speech that they view to be a clear and present danger. So essentially, this is the thing that people always remember about this case, which is you don't have the right, although you do have the right to express your opinion, you do not have the right to create an unsafe or a dangerous situation. So there's the famous thing about yelling fire in a crowded movie theater just as a prank. You can't do that. You've created a dangerous situation, and it's not allowed. So it's an example of a limitation on the First Amendment. So as we look at the rest of these cases here, I want you to ask yourself, is the thing that I'm describing an example of creating a dangerous or a harmful situation for the people? If yes, then the government can make laws to prevent it. If not, then those laws or those actions are unconstitutional. So the first case that we'll look at looking at the standard is Tinker versus Des Moines. This is, of course, the case where the students in schools were looking to protest the war in Vietnam. They wore the black armband with the peace sign on it. They were suspended because this violated the school dress code. They said that this punishment infringed on their right to petition, to protest. The school obviously disagreed, but the Supreme Court said that it was unconstitutional, that students do have the right to protest. The school does have the right to keep things orderly and to prevent disruption. So the Supreme Court applied the standard, saying basically if the protest that the students are trying to do is creating something unsafe, or if it's disrupting the learning environment, then the school could say no. But just wearing a black armband on your arm along with the rest of your uniform is not disruptive. It doesn't bother anybody, so it should be allowed. So Tinker versus Des Moines, students do have free speech in school. The next case is Hazelwood versus Kuhlmeier. This is, of course, the case dealing with student newspapers at a high school. The principal said that articles that the newspaper was going to write dealing with divorce and teen pregnancy was inappropriate and censored the articles, saying that they could not run in the school newspaper. The students said that this violated their right to freedom of the press. The Supreme Court, however, disagreed, essentially saying that students do have the right to express themselves personally, but the school also has the right to create rules dealing with content that goes on in their organization. So, in class I said to think of this as, you may be in the basketball team or the soccer team, or you might be in the debate team, and the coach or the person who runs that can say that you can't use profanity. That's not violating your right to freedom of speech. That's saying in this club or in this organization, in this school, we do not talk about this stuff, or we don't use these words. If you don't want to abide by those rules, that's fine, but you're just not going to be a part of the soccer team or the basketball team or the debate club or whatever. So that's Hazelwood versus Kuhlmeier. And I told you to remember, because wood comes from a tree and newspapers are printed on paper that comes from a tree. So the Hazelwood newspapers printed on paper. Then we have West Virginia versus Barnette, another case dealing with schools. This one was where the group of Jehovah's Witness students refused to stand for the Pledge of Allegiance. School rules and district rules in West Virginia were such that students were required to stand for the pledge, and these students did not, so they were expelled. And their parents said that this violated their right to freedom of religion, that students are humans, and humans have an innate right to exercise their religious beliefs, and that the school was wrong. And the Supreme Court completely agreed that you can't force people to stand for the pledge or to show any sort of patriotic anything. You can't force people to do that, because you have the right to either not agree and still be in America, or you have the right to simply just exercise your religion. Freedom of religion in schools as well. This case, when we talked about it, I kind of connected it to the current controversy about people kneeling or standing for the Pledge of Allegiance, in the sense that, you can't be punished for having an alternative opinion about that. So that's West Virginia versus Barnette. Lastly, we're going to talk about Texas versus Johnson. Now, this is the case where the man, Johnson, was arrested outside of a Republican National Convention. He was protesting the Republican president there, and he did so by burning his American flag. Now, you might be thinking, well, burning things in public, that's obviously a safety danger, so shouldn't the government be able to prevent that, according to the Schenck case? And that'd be an interesting thing. However, Texas law did not say you cannot burn things in public. Texas law here said you cannot burn or destroy any patriotic symbol. So that includes flags, I guess statues of Thomas Jefferson or George Washington, or, I don't know, punching an eagle or something. The law itself was very specific on what you can't destroy, which is a patriotic symbol. And this is a very controversial thing, but in essence, it was Johnson's flag. And if I wanted to express my opinion about America by burning or destroying my own flag or my own, patriotic symbol, Johnson said that this is my right to freedom of speech, that if I want to express that opinion by destroying my own property, that's my right. And ultimately, the Supreme Court agreed that, a law that bans an expression of a political opinion, that being that I don't like America, while you might not particularly like that opinion, or you might not like that someone's doing that, ultimately, just because you don't like it doesn't mean that it's against the law. While this might have been a public safety risk in terms of burning something, the law that was being applied here was not you created a public safety risk by burning a Ziploc bag. The law that was applied here was that you offended our country or disrespected our country by burning a flag, and that sort of law was unconstitutional, and that's what the Supreme Court said, that it violated freedom of speech or freedom of expression. So those are 5 cases, all dealing with different parts of the First Amendment. There are others as well, but in this case, in this video, we're only going to focus on those 5 things. So Schenck says the standard that we're looking for here is a public safety risk. In Tinker, students can use their freedom of speech as long as it's not disruptive. Hazelwood, students do not have freedom of the press when it comes to newspapers. West Virginia versus Barnette, students have the right to practice their religion within their schools, can't be forced to not practice their religion. And lastly, we've got Texas versus Johnson, which talks about the flag burning. All right, good luck.